SJC-11563, Assabet Valley Regional Vocational School District, v. Anne Marie Speicher.
Good morning.
Good morning, Chief Justice and Associate Justices. May it please the Court, my name is Tim Norris, and I represent the Assabet Valley Regional School District.
Mr. Norris, can I ask you this question? The school system alleged that how do you pronounce her name, Speicher?
Speicher.
Speicher. That Ms. Speicher engaged in conduct unbecoming a teacher and suspended her accordingly, right?
Yes, Your Honor.
And she selected, as she had a right to do, an arbitration.
Yes, Your Honor.
Okay. And the arbitrator said the school district has not adequately supported its claim, and therefore I fine for the school teacher. What's wrong with that?
Well, there's no doubt that there's no just cause requirement, no substantive
Leave just
standard.
cause aside, that carries a lot of baggage. Just focus on why was it wrong for the arbitrator to say, at the end of the day, you didn't support your claim, you didn't prove conduct unbecoming, you had the burden to do it.
Because the arbitrator's source of authority is a statute, and the statute is Section 42D. That statute lays out what the school district's responsibilities are in regard to a suspension.
Well, surely its responsibilities include proving it, proving the conduct underlying it, doesn't it?
No, Your Honor, it doesn't.
Well, what's an arbitration all about then?
It's all about the procedural, that you get the notice, and that's all you're saying is the arbitration is about?
Well, arbitrators are accustomed to reading language in a contract, and in this case in a statute, and determining whether the conduct of the employer violated the language. So, there are plenty of cases where the question is, was the grievant entitled to this personal day, or was the grievant entitled to a longevity payment? So it's not always, about, it's often about, for arbitrators, looking at the language that gives life to the arbitration, in often a contract. But, in this case, the language is a statute. And what the arbitrator is doing is measuring the employer's conduct against the statute that gives the arbitrator the authority to act.
But so you're basically saying that even if you had said that she was being suspended for conduct unbecoming a teacher, and the only basis for that was that she had looked at somebody the wrong way, but that was, that it's not, the arbitrator has no authority to do anything on this review of the suspension other than to view the steps taken in reaching it, and that's it. Has no substantive review.
Your Honor, if the arbitration were brought under a collective bargaining agreement, subject to a just cause provision or some substantive standard of review, whether it be good cause or arbitrary and capricious, then the arbitrator would have that opportunity. But in this case, it was brought under 42D, which really establishes a floor.
But once the school had decided to suspend her for a reason recognized by Section 42, right? I mean, if the school had just said you're suspended, and we followed all the procedures, but didn't do it for one of the reasons that was in the termination section.
Or didn't do it for any reason?
Didn't do it for any, your view is that the school could suspend her or any employee for any reason so long as they followed the procedural requirements in 42D.
Essentially, that's the guarantee of 42D, is that the school district will meet the procedural requirements. Now, obviously, these are people, vessels of the public trust who are making these decisions, and so, we expect that they'll have reasons for their decisions. But when we talk about, due process in a constitutional context, we're talking about whether the employer or the decision maker had a procedure or a process that would guard against rash decisions that are ill-considered. And so the reason that we have due process is not to make sure that the decision maker gets it right. It's to make sure that the decision maker has an opportunity to get it right, because and that the person subject to the deprivation has an opportunity to help the decision maker get it right, because they've been given notice of the offense.
But forgive me, on that analysis, the arbitrator, I don't think, on your view, can look to see whether or not, there was a getting it right at all. I mean, so long as the meeting took place, so long as all of the procedural things happened, whether or not, there was any real substance to it. You can presume that it's all going to be done in the best of intentions and so forth. But you're saying the arbitrator cannot look into that. The arbitrator is just basically looking to see whether the mechanics were done.
I agree with you, Your Honor, I agree with that. That is my argument. The arbitrator is looking to make sure the mechanics are in place, as they are in the due process context, to make sure that the decision maker gets it right. But the due process, when courts review based on due process, they're not looking at the merits of the decision, except in very unusual cases, these sort of what you call a substantive due process. It's an oxymoron that has its own name because it's the exception rather than the rule in reviewing of process.
But if that were the case, why would the legislature even require a case to go to arbitrators? Why wouldn't it go to a court? You wouldn't have to pay for the court to do that meager a decision-making process, go through that meager a decision-making process. But you do have to pay the arbitrator. It seems cost inefficient to do it that way.
Well, I guess it depends on the cost that you're measuring. One might not have to pay a court, Your Honor, but one would certainly have to spend the time. If we're talking about a suspension and someone has been, suspended, I mean, these are not long-term suspensions. These are anywhere from 1 day up to 1 month, which would really, in a school month, would be 15 or 20 days.
But if the only question is procedural safeguard, were procedural safeguards followed, there's nothing to that.
Well, Your Honor, I mean, there's one substantive piece of 42D, and that's the length of the suspension. But I don't know that there's nothing to procedural safeguards. There's a whole body of jurisprudence around due process, and that is all about procedural safeguards. And really, in this case, the legislature has set forth what the procedural safeguards are. And it's true that this interpretation, which I believe is really, it is the plain language of the statute. This interpretation might reduce the number of arbitrations over suspensions brought under the statute, but I don't think the legislature was trying to create work for arbitrators.
Are you saying that a school district could be arbitrary and capricious and suspend someone for a reason that had no basis whatsoever, and as long as they followed the proper procedure, there would be no remedy available?
Your Honor, as long as...
Is that what you're saying?
Yes, Your Honor.
So if you get suspended for having blue
Does that
hair,
sound fair?
Well, I mean, the point is how deep are we going to go in terms of legislating discretionary decisions of public employers? I mean, there certainly is a check against, when employees unionize, there's a check against, arbitrary decisions by employers when the unions negotiate just cause provisions. I don't think the legislature was intending to occupy the field on suspensions. In fact, the statute in 42D says that this doesn't impair any collective bargaining agreements on the subject of suspensions. This is in contrast to 42, which does occupy the field on teacher dismissals. 42D is broad-based. It applies to every employee of the school district, not just teachers, not just professional status teachers, not just folks with just cause protection, but it applies to everybody. So it's best read as a baseline procedural protection. And, you know, individuals in individual contracts and, you know, where those are available, in the case of administrators, and unionized employees are able to supply more. I mean, and there are certain school district employees who are at-will employees, and they can be fired arbitrarily and capriciously. I mean, it's certainly not how we like to think of ourselves doing business in public employment. It can happen. Hopefully it doesn't happen. You know, the idea behind having a procedural safeguard is to make sure that there's ample opportunity to deliberate and not reach a bad decision.
So if you prevail and we issue an opinion in this case, you wouldn't have a problem if we said it's okay going forward to be arbitrary and capricious when you're going to suspend a teacher?
Well, I don't, Your Honor, I don't think that's, I don't think anyone should be encouraged to be arbitrary and
But
capricious.
that would be the holding, wouldn't it? As long as you comply with the procedural steps, you're okay.
Under 42D, yes, Your Honor. I mean, most employees in school districts are going to have protections through their collective bargaining agreements.
But don't you think that in the language of the statute, which says that the teacher has to be given, or that employee has to be given 7 days written notice and the grounds, and then has an opportunity to have various hearings and the opportunity to provide information pertinent to the decision? I take it that means the substantive decision, right?
Yes, Your Honor.
So wouldn't it follow from that, without importing a good cause or just cause standard, that at the very least the arbitrator gets to see whether the grounds that the suspension was, and gets to evaluate whether the grounds on which the suspension was based were established by the school committee,
Well, Your
by the
Honor,
principal or the superintendent?
I think those are two different things. I mean, one of them is, you know, your basic Loudermill type due process, where you get a written notice of the discipline and the basis of the discipline. If an employer is being judged on the basis of a due process claim, the court doesn't look behind the decision-making to decide whether it agreed with the employer making the decision. The court looks at, you know, was there notice and an opportunity to be heard, and how much notice, how much of an opportunity to be heard, how formal of a hearing, how formal of a notice. Those are all things that are on a sliding scale based upon the size of the deprivation. So this is just like that. This is a baseline procedural protection. I mean, otherwise, you know, we would have to ask, what is the source in the statute? I mean, this is a plain language statutory interpretation case. Just cause or any substantive standard other than the duration of the suspension is not present in that statute.
So now, if the judge had, if the arbitrator had made an error of law, you would not be here, correct?
If the arbitrator had made an error of law other than an error of law in interpreting his own jurisdiction under the enabling statute.
Well, but the problem I guess I have is, how can we say an arbitrator exceeded his or her authority when the limits of that authority are not clear? I mean, isn't that an error of law?
Your Honor, I think that, I mean, first of all, I think this is a case that is as reviewable as the case in Beverly versus Geller and Atwater versus Commissioner. I mean, this is basically an arbitrator adding a just cause requirement where it does not exist in the statute.
I mean, I really don't quite see that at all. I mean, it would be one thing if the arbitrator here said, I find that indeed the teacher did what she was alleged to have done, which was the basis for the suspension. And oh, by the way, I think the punishment was too much, I'm going with 10 days. You know, because of the just cause progressive discipline standard, which I agree doesn't apply, but that's not what happened here. Arbitrator said, not established. The underlying misconduct was simply not established. So, well, again, I'm trying to figure out why the arbitrator can't make that decision.
Well, Your Honor, I mean, the arbitrator specifically said that based on a just cause analysis.
Yeah, it said that, but if you look at what the arbitrator actually concluded at the end, said, you have not established the school committee has not established the violation.
I actually focused on the failure to investigate, that they hadn't
Well, two
spoken
things.
to the people who they need to speak with to
Well,
make that
there
finding.
were two things. The district did not meet its burden of proof, okay, to establish the underlying conduct.
Well, the burden of proof, Your Honor, comes along with the just cause requirement. I mean, this was basically, this was a credibility contest between two teachers, essentially. One teacher that said that Ms. Speicher said something, and Ms. Speicher said she didn't. I mean, that is the hallmark of a just cause analysis. I mean, if we go to the statute, basically what we have is we have procedural limitations. Importing the section 42 arbitration procedures, it says specifically procedures, doesn't import the substantive standard. The idea that seeking review of the suspension is, somehow a substantive review for just cause doesn't make sense, because the term review is such a vanilla term that could, encompass many different levels of review.
Thank you, counsel.
Thank you, Your Honor.
I'm not sure if it's afternoon or morning.
It's
but,
on the cusp.
Good day,
Right on the edge.
Chief Justice and Associate Justices. May it please the court. I'm Sheila McCarthy, and I'm here on behalf of Anne Marie Speicher. I guess what I would like to suggest is that if the court were to adopt the position advanced here by the school district, it would be a fairly substantial departure from this court's prior decisions with regard to the scope of an arbitrator's authority, even those decisions that have explored the scope of an arbitrator's authority when it arises under Chapter 71 as opposed to under a collective bargaining agreement.
Ms. McCarthy, you take the position that the arbitrator properly imported a just cause or good cause standard. But do you really even need to go that far in this case? I mean, if you sort of look at, following up on what Justice Cordy said, but isn't one way of looking at this that the arbitrator did not find that the school committee had met its burden to show that the teacher committed the conduct that they said was the basis of the suspension, lying?
I think that that's a fair way of looking at this case. I mean, ultimately, the basic issue before this court is whether or not the arbitrator exceeded the scope of his authority. And as I've, I think, articulated in the brief I submitted on behalf of Ms. Speicher, there isn't any indication that he did in this case. He made a determination as to how he was going to review this case. He went about methodically reviewing this case that way and came to the conclusion, as has already been pointed out, that in fact the employer did not meet its burden of proof, which is also something that's required under Section 42 as opposed to Section 42D, which is silent on the question of whose burden of proof it is in an arbitration.
I can't remember. Does the school committee argue that it's actually the teachers in a suspension case?
I'm sorry.
Does I can't remember, and I didn't ask, whose burden it is, the school committee's position in terms of whose burden it is.
As I pointed out in my brief, Your Honor, the school committee makes one simple argument as to how this arbitrator exceeded the scope of his authority. It does not contend that the arbitrator exceeded his scope of authority by requiring the school district to proceed and that they had the burden of proof. That is not something that's, that has been argued by the school district. So
how should we interpret the statute in terms of what the standard is?
well, Your Honor, in the brief that I've submitted on behalf of Ms. Speicher, I've suggested that perhaps, again, when you go back to your touchstone, which is what is the scope of an arbitrator's authority, in this case, he was presented with a specific set of facts. He was presented with a case that involved a teacher who undeniably had earned professional teacher status. And so he made his decision with that in mind and found that in this case, just cause was appropriate, as I pointed out. And
I'm not quite sure what what you mean by just cause was appropriate. Just cause was appropriate because she had professional teacher status?
I think if I read the arbitrator's decision correctly, I believe that he made the determination that some substantive standard of review was appropriate. He called it just cause. Ultimately, he came to the conclusion that.
Well, if the arbitrator found that, in fact, Ms. Speicher lied to another teacher to cover up the conduct of a student, if that's what the arbitrator found, that the school had established that she lied in this fashion, wouldn't that be conduct unbecoming?
I think the hypothetical that Justice Cordy is posing is an interesting one. Obviously, that's not what this arbitrator found. He, as you've pointed out, Your Honor, the arbitrator found quite to the contrary, that there wasn't a demonstration.
Evidence of that.
Correct.
But the conduct unbecoming is itself something that comes from 42 and relates to terminations of tenured tenured teachers, right?
In section 42, which is referenced, of course, in section 42D, but in section 42, yes, Justice Lenk, you're correct, that section 42 deals with the issue of dismissals and demotions for teachers with professional status, and it lists 6 different
And conduct
enumerated-
unbecoming is one of them.
Correct.
And now, so that actually is a good segue to the thing about this that really sort of troubles me, and I think it's following up on Justice Gantz's question, which is, I think that the school is basically saying that there would be an absurd result if we construed the statute in the way that you suggest, because there would be because the statute 42D regards suspensions of all employees. That would include not only tenured and but non-tenured teachers and other members of the staff, for example, a custodian, at-will employees, people who would, on his reading, say that a custodian, for example, without any rights to challenge a dismissal, unlike a tenured teacher under 42, would be able to challenge a suspension if the arbitrator introduced a standard, such as where you really have to have a basis for doing what you did.
I understand the court's concern. However, I think, again, at the risk of sounding simplistic, hearkening back to the touchstone, which is what's the arbitrator's authority in this case, remembering that an arbitrator's decision doesn't have any precedential value. It's not something that necessarily has any, certainly no mandatory authority. It may have persuasive authority in certain cases, but in this case, on these facts, this arbitrator made the decision that that just cause was an appropriate standard. Remember that in Section 42, it enumerates the different bases on which a dismissal or demotion of a teacher with professional status can be made, and then, the proper grounds, and the last one being or other just cause. So that's sort of the catch-all at the
That's
end.
for tenured teachers. It's not for anybody else.
Which is, well, in this case, we're talking,
42 and the grounds that are given there, that only applies to the dismissal or.
well, that is true. However, if you take, and this is an argument that I've made in this case, advanced in this case, that hasn't, that I'm aware of, been addressed by the appellant. If you take this case to its logical conclusion and say that an employer, a school district in this case, obviously, can suspend, as long as they jump through the necessary procedural hoops, they may suspend a teacher who has earned professional teacher status for periods of up to 30 days. They can do that consecutively and effectively dismiss a teacher, end a teacher's employment in a school district. And that is among, several reasons that I have argued the way that the arbitrator approached this case in no way exceeded the scope of his authority. And that is ultimately what needs to be determined here. How did he exceed the scope of his authority? There's nothing on the face of the statute, as the judge in the Superior Court indicated, this is not a plain meaning. If it was plain meaning, the fact that both sides have articulated a somewhat plausible argument for how to interpret Section 42D certainly suggests that there's not real plain meaning here, but the question here is, has the plain meaning been abrogated? Did the arbitrator ignore the plain meaning? Did the arbitrator exceed the scope of his authority? When the legislature enacted the Education Reform Act almost 21 years ago now, they did so, of course, as we all know, presumably aware of the body of law that existed at that time and aware of the strong public policy that supports arbitrations. They were also aware of the decisions that existed before they enacted the law that said that if you're going to limit an arbitrator's authority, you have to be very clear about it. And I would also suggest that if the court looks at the statute and interprets it as a consistent whole, which I think it should, perhaps must, the legislature certainly knew how to limit an arbitrator's authority if it needed to, if it chose to, and it did. If you look, for example, at Chapter 71, Section 41, I believe it's the second and third paragraphs that deal specifically with the question of dismissal and demotion of building principals, assistant principals, department heads, and other supervisors. In that section of the statute, very clearly, the legislature made the opening line of the third paragraph, I'm sorry, maybe the fourth paragraph. Helps to look at the right section, pardon me. Except as provided herein, Section 42 shall not apply. So the legislature made very sure that no arbitrator would make the mistake of applying the just cause standard, for example, to a building principal, assistant principal, department head, or other supervisor who had held their position in the district for 3 or more years, when in Section 41, the section I just quoted from, the standard for an arbitrator is good cause. And we know, because of the cases that have been decided in the period since the Education Reform Act was enacted, that good cause and just cause are different. That just cause is a higher standard, and that's the standard that's been given to teachers who have earned their status as professional teachers.
Is your client a member of a union?
I believe she was, yes.
And was there any provision in the contract, the CBA, that dealt with the standard for suspension?
Not that I'm aware of, Your Honor. And that's another way of saying that education reform provided teachers with the ability to earn a certain, as the Atwater case says, some measure of job security, which is one of the fundamental public policies that the Education Reform Act sought to realize. And it's a statutory right. There may be, as Section 42D says, that doesn't mean that the parties, a school district and a union, couldn't negotiate other terms with regard to suspensions.
So that Section 42D is one of the statutes it's listed under, I think it's 150E, Section 7, that can be overridden by the terms of a collective bargaining agreement?
Well, I think, Your Honor,
42D specifically says.
that.
at last
Right in it.
check, actually, it's not one of the enumerated statutes under Section 7D of Chapter 150E. However, Section 40, the last sentence of Section 42D makes it very clear that the parties are free to contract. And I would submit to contract to make the right superior or inferior. I mean, in other words, there's nothing saying that the parties couldn't agree, well, if it's a suspension for,
is this where, do you practice in this area?
I'm a labor and employment lawyer, yes.
And I just wondered whether generally in schools, whether teachers or custodians, whatever, there are provisions in the CBAs that have, that deal with this, with suspension standards.
Sometimes yes, sometimes no, has been my experience. Obviously, that's not in the record. I will refer the court, though, to the amicus brief that was filed by the Massachusetts Teachers Association. Obviously, that entity has vast experience in this area, and they, you know, part of that, their brief, they discuss how sometimes it applies, sometimes it doesn't. What happens when the collective bargaining agreement expires and there's a gap between? Does the person who has earned their professional teacher status suddenly fall through the cracks and get no substantive review? I would submit no.
But you're not telling us that we should remain silent as to the standard so that any arbitrator in the future can develop whatever he or she thinks is the standard, are you?
Your Honor, I would never presume to tell you what you can or can't do. I would respectfully suggest that in this case, the facts are the facts. You know, what we're presented with is really, I think, the issue at hand. And I do believe that the legislature, in its wisdom, converted this dispute to an arbitration forum under the statute instead of the old-fashioned way of doing it in front of a school committee. Partly because it had a basic understanding and a basic trust in arbitrators to make those determinations.
But if you're right, then you may find an arbitrator who believes what your brother says, and the next arbitration would say there is no standard. All you're entitled to is the procedure. And you would say that's okay too?
I certainly, on my watch, I wouldn't likely say that's okay. However, for all we know, Justice Gantz, that's happened because, as I've pointed out, these cases are not, you know, have no precedential
So if we
value.
set a standard, if the statute's not clear and we set a standard, then an arbitrator who departs from it may exceed his or her authority because we've established the standard.
Correct. If you set a standard and the arbitrator departs from it, absolutely, the arbitrator will have exceeded his
But right
authority.
now you say they can't exceed the authority because there is no authority that guides what an arbitrator is supposed to do.
Well, I'm not sure that I would say he can't exceed his authority, but I would say that in this case, on these facts, he certainly hasn't. And I know that the Massachusetts Teachers Association takes the position that, in fact, the just cause standard from Section 42 has been imported into Section 42D, and I don't find that their argument unreasonable or wrong. It's not an argument I made because I came to this court with a certain set of facts and presented my arguments accordingly.
Counsel, your time is up. Thank you very much.
Thank you.